Time of the gentleman has expired. The gentleman from South Carolina, Mr. Gowdy.
Thank you, Mr. Chairman. Mr. Weinstein, you said leaks have been around for time immemorial. It strikes me one way to have fewer leaks is to actually prosecute and put in prison the people who do the leaking. So I want to talk to you for a second. I couldn't find a federal statutory reporter privilege. Am I missing it?
You couldn't find a reporter privilege? No, you're right.
It doesn't exist in statute, so then we'd have to turn to the common law, and I'm not aware of any privileges that are unqualified, and certainly the reporter's privilege would be limited and would be qualified. So then we move to this area where, because it's the First Amendment, heavens knows we can't have any limitations on that. So I thought maybe you and I, together with the help from our friends who are law professors, could come up with some examples on where there are limitations of people's First Amendment rights. I'll go first. Obscenity. What's another one, Professor?
Well, in Near versus Minnesota, the Supreme Court...
You don't have to cite the cases.
Information about ships' sailing dates and troop...
How about deceptive advertising? How about students on high school campuses? They don't have the full panoply of First Amendment rights. How about libel? How about government employees? So the notion that the First Amendment has no limitations whatsoever is balderdash, legally and otherwise. So that then leaves me with this conclusion. We are asking the U.S. Attorney, I think in the District of Columbia, to investigate leaks, and if he follows DOJ policy, he has to ask the Attorney General 4 months shy of an election for permission to subpoena a reporter in a case that may wind up being embarrassing for this administration. So why do we not have a special prosecutor in this case?
I think, Congressman, you're referring to the internal DOJ guidelines that require that the Attorney General personally sign off on a request to subpoena a reporter.
That's exactly right. DOJ policy.
It is DOJ policy. It's in place to protect the free press, to make sure that prosecutions don't chill the exercise of free press.
Right. It's certainly not the law. That's just DOJ policy.
It's not the law. If you look at the Espionage Act, there's nothing in the Espionage Act. As you pointed out, there's no privilege. Keep in mind, however, you can make leak investigations and leak prosecutions without actually subpoenaing the reporter.
You can, but you can also win murder cases without calling the eyewitnesses. Right. You can win a murder case without calling the DNA expert. Why not send a subpoena to the reporter? Put them in front of a grand jury. You either answer the question or you're going to be held in contempt and go to jail, which is what I thought all reporters aspired to anyway.
Well,
I mean, all of us aspire to be committee chairman. I thought that was the crown jewel in a reporter's resume, is to actually go to jail protecting a source. Give them what they want.